My first sentence shall be the judgment of the Honorable Supreme Court has absolutely clarified that who are tainted and also who are not tainted. The same judgment also have shown that we are not tainted. Kindly take my love, paragraph 3, Boishaki.
Yes.
Paragraph 3 equals to two categories. Short para, the appellants before us are the selectees, some of whom have been working for over 5 years. They fall into two categories. Category number 1, selectees with purported evidence and material indicating wrongdoing. Number 2, other selectees who claim that they were validly selected and have committed no wrongdoing. So that's the beginning of the Boishaki. One, some evidence wrongdoing, some they are claiming. That's we. Kindly take paragraph 22.
Yes.
We have 4 reports submitted by CBI. We would like to quote some of the passages from the report dated such and such submitted by the CBI in compliance with the order dated such and such by the High Court. Now, thereafter, quoting started. Lordship may kindly come to internal quoting paragraph 9. That is page 25.
Yes.
That during investigation, the server database, kindly mark this portion because there are two aspects. One is what SSC claimed, that was taken by the CBI. Another was seized from the Pankaj Bansal. That during investigation, the server database of the commission was seized by the Central Bureau of Investigations containing, these 3 words are important for us, all the data pertaining to selections test group D, group C, 9, 10, 11, 12. So internal paragraph 9 equals to entire data of SSC seized by the CBI. Next paragraph 10. That during investigation of the case, 3 hard disks were recovered on such and such date from the residence of Pankaj Bansal, ex-employee of Messrs. Naisa. Lordship need not read that. Now kindly come to paragraph 11, the last 3 lines, which establishes that the data contained in the 3 hard disks recovered from Pankaj Bansal's possessions were not contaminated. One seized from the SSC server, another from the Pankaj. CBI found Pankaj data not contaminated. Kindly thereafter paragraph 12. That a similar exercise of matching the data available on the hard disk of Pankaj Bansals with the data seized from the commission was done during the course of investigation, and it was found that there were mismatch between the two. This is the beginning. In as much as the written marks awarded to candidates as available on the server of the commission had been increased to qualify undeserving candidates. This mismatch establishes that manipulation in marks of written examinations in the case of many candidates was resorted to, and such candidates, kindly mark this, were identified. Full stop. The comparison of this actual/genuine OMR marks with the OMR marks available in West Bengal School Service Commission server shows that there is manipulation in 952 numbers of candidates of some, there are numbers. So before moving ahead, CBI found genuine data with Pankaj. CBI found data from SSC. CBI matched. What was matched? Not few. All the data with the SSC, all the data with the Pankaj comprised of everyone. Group D, Group C, 9, 10, 11, 12. All were matched. After that, it was found X, Y, Z numbers were not matching. Thereafter, kindly take 13. That during the course of investigation, several emails were found to have been exchanged between the accused officials of the commission, certain private persons, and officials of NISA. These emails contained list of candidates whose OMR marks were found to be increased in the server of the commission. I'm trying to show the meaning spread over everywhere in the judgment of the Honorable Supreme Court regarding identified. And then contrast why the Honorable Supreme Court has said not specifically identified, they will get these benefits, not everyone. Besides this, emails have been exchanged between the staff of NISA themselves containing manipulated data of candidates. This shows the complicity of the officials, such as not necessary. Thereafter, kindly see internal 15, next page, just first 4 lines. That it has emerged from the investigation that before leaving NISA, Niladri Das and his staff retained all the data. Well, I'm only on the point, all the data pertaining to recruitment of such and such, including data of CD with them. Thereafter, 18A on identification. As discussed in the preceding paragraph, the hard disk recovered from Pankaj Bansal contained the marks of written examinations, typing text, etc. These marks, when compared with the marks available with West Bengal School Service Commission server, resulted in the identification of candidates whose marks of written examination, typing test were manipulated. So the paragraphs are going in the same tune. Now, internal para 21. That the present status of all the above mentioned 4 recruitment cases of CBI is disposed of from investigation, where multiple charge sheets in each such cases have been filed by the CBI before the learned trial court. Now, kindly see, my lord, thereafter, this is by the Honorable Supreme Court. The facts stated in a report dated such and such submitted by the CBI speak for themselves. Thereafter, paragraph 25, my lord, before I place 25, after recording what CBI has found and without adding anything, the Honorable Supreme Court having said it's fixed. So that's what the truth CBI is saying. So far as this matter which was before the Honorable Supreme Court, after that, the Honorable Supreme Court also did an exercise in the table number 1, paragraph 25, for identification. First, paragraph 25, in the written submissions filed on behalf of the School Service Commission in this court, 2 tables have been furnished. Table 1 pertains to candidates who either jump rank or were appointed despite not being in the panel. Lordship may kindly see the numbers. Table 1, since I'm not taking the number of the group C and D, since I'm appearing for the 9, 10 and 11, 12. So rank jumped 74, 20 and out of panel 111 and 18. So total 185, 38. So total I have made a calculation. It is 223. Lordship may kindly mark 223 equals to rank jump and out of panel. Now table 2. This is the manipulating of the OMR sheets. In C and D, the number was so much. So I'm not touching that. Lordship will see there are 2 columns. One was the number of candidates with alleged OMR score mismatch as per the CBI image. That's a Pankaj when compared with the SSC. And out of that, actually who got the benefit, who were appointed. So that figures, Lordship will see 808 and 772. So put together 1580 is the figure. So 223 and appointed based on this OMR corruption 1580. Now 1580 was further verified, paragraph 26. In another written submission filed on behalf of the School Service Commission in this court, it is claimed that on further verification, the following details of the candidates, it either jump rank or were appointed despite not being personal, and thereafter they gave a figure. What I found is the only change was there that rank jump there 74, 20, 100. So there is no change. In B, there is a change. 1580, which was the total, now it became 1568. Lordship may kindly see capital B, persons identified having dispute in OMR issue. The numbers are there 796 and 772. If Lordship add these two, it becomes 1568. Now, that number is not that important. All I'm thereafter, Lordship may kindly see the language of the Honorable Supreme Court. Page number 30, last paragraph. 1498 out of panel candidates were illegally appointed. We don't belong to them because 926 candidates were involved in the rank jumping. We also don't belong to them. 4,091 candidates were recommended. Let me kindly mark this 4,091 equals to all teachers equals to 1791 because it is 1568 plus 223. So it becomes 1791. In fact, that's the reason the Honorable Supreme Court did not grant Group C and D to continue their service because they found the massive corruption was statistically more in Group D and C. So 4,091 is the number specified, identified by the Honorable Supreme Court on the basis of the CBI's report, which was accepted by the Honorable Supreme Court. Out of 4,091, if Lordship take the figures from the table itself, I have calculated the detailed calculations, Lordship has to add it. 1568, which was originally 1580. If I give the number, Lordship kindly take.
Anyway, the numbers are not.
Yes, number is not important, right? Just that's the for idea purpose. Lordship can take the number because I have checked myself. 1791 is the number for the teachers. 1,791 teachers, their marks in a corrupt method were increased, which was detected, found, identified, and recorded by the Honorable Supreme Court. So this is the context. In this context, thereafter, Lordship may kindly come. Paragraph 31, which was relied by Mr. Bhattacharya.
Yes.
West Bengal School Service Commission has also tried to justify the extension of the term of the panel as noted above. The time period of 1 year specified in Rule 21 for the destruction of the OMRs coincides with the time period specified for the validity of the panel. There is no doubt that the counseling process and appointments made to the post of assistant teacher class 9, 10, 11, 12 were made after the expiry of panel. This is illegal and contrary to the rules. Reliance on the orders, judgments of the High Court in stray cases of rank jumping where the High Court directed to appoint candidates after the expiry of the validity of the panel would not have any significant impact. The court at this stage was not concerned and aware of illegalities in the appointment procedure and had, kindly mark these 3 words, not specifically examined the question of appointment after the expiry of panel. Paragraph 31, according to my understanding, is after expiry equals to illegal. Yes, I agree up to this. Yes, after expiry has been found, after expiry appointment has been found by the Honorable Supreme Court illegal. Now thereafter, kindly take paragraph 45. Well, because that's the main paragraph, before I place it, what I have found from the reading, when Lordship reads it in entirety, Lordship will find there is a 2 completely separate branch. One branch is coming from paragraph 46 and paragraph 47, coupled with 31, that is we. 46, 47, 31 illegal, that's we. And there is a conspicuously differently identified branch is in paragraph 22, that internal paragraphs, read with 25, 26, that identification of the column, and then paragraph 45. So may I kindly take 45 first. So 45 is the result of one. I would also try to argue against me to find out whether my point has any negativity, so that I can, my lord, pass my point also. I stretch 31 to fullest extent to mean that 31 means illegality, and therefore, once it is illegal, whatever are the directions which touches upon illegality, that will also touch me. So I take that. So I want to address that. So after I said dealing with in two different way. One way of dealing was identifications based on Pankaj's data, and the other is the institutional failure and illegality in 31. Now the Honorable Supreme Court comes to what is to be done. First is 45. The last question relates to the relief and whether it requires any modification. We find no valid ground on reason to interfere with the directions of the High Court that the services of tainted candidates where appointment must be terminated and they should be required to refund and salaries payments received, since their appointments were the result of fraud. This amounts to cheating. Therefore, we see no justification to alter this direction. Kindly also read 45 with 51. Kindly read 51 also. Accordingly, we uphold the impugned judgment, cancelling a block entire selection process. But this but is the according to me our savior. But have made certain modifications in the directions issued by the High Court. So now I have to show before your lordship what is that but. Kindly come to 46. So 45, to me, 45 equals to fraud, cheating. So the Honorable Single Judge was right in direction for not only termination but also refund of money. That's all 45. That if I say once more, since there, the word there, I would relate with paragraph 25, 26, which is based on CBI's 22. Fraud. Now, why do I do so? Because the very next paragraph, there is a separate branch altogether, where there is the modification has been made and for a reason. For candidates, now this is 46, not specifically found to be tainted. I just pause for 1 second. There is a difference between two sentences: for a candidate not found to be tainted and for a candidate not specifically found to be tainted. My understanding is this, that the Honorable Supreme Court took the pain of that 4 reports of the CBI, read each of the parts of the CBI report, and thereafter found that there is a truthfulness, and then that chart was made. That identification of the chart, according to me, is the specifically found to be tainted. The entire selection process has been rightly declared null and void due to egregious violations and illegalities, which violated Article 14 and 16 of the Constitution. So therefore, if I use these synonymous words for candidates not specifically found to be tainted, so I want to use as we. Why? Before I proceed, kindly, my lord, for the time being, assume there is no judgment of the Honorable Sir for the time being, because lordship would be seeing not only from just a point of law, also lordship would be seeing independently also. Kindly visualize of a situations that as a candidate, I have participated in the competitive examination. I have found that my name is there in the panel. I am waiting so that one day I would be appointed. That's a very normal phenomena we see in the society. I get information that counseling starts, you come. I go there. I am successful because my name was there and I am appointed. Kindly, my lord, visualize this most ordinary common phenomena existing in our society. If anything is not attached to that particular candidate, like he has paid money or he has used some other method, his or her act of responding to the counseling for getting the job because he or she was in the panel, can anyone say in for any stretch of imagination that that is an act of fraud? I'm just, because after all, law is not that something, society is one thing, law is a completely different thing. It's society to run in a properly. That's the whole purpose of the law. And in a deeper level, that's a justice. I was only trying to understand this, that I prepared, I sat in the examination, I found that I am successful, I am waiting. And contrast it with the institutional failure. Because in the SSC, they have said there was some orders, some difficulty, and that's why even the first counseling started after 6 months. So ultimately, when 7th counseling happened, couple of months were delayed. So if Lordship takes into account 1 year, right. In fact, my instruction is that this mismatches the numbers. More are in the first counseling and second counseling. So leaving aside that, there are large number of petitions also, usually, not in this case, also come before this honorable court saying that my name is in the panel and I have a genuine grievance that I have not been called. Usually some kind of directions are given because there is no fraud in that. So what is my respectful submission is that fundamentally for a candidate to wait for a call for counseling because he or she has done good and her or his name is there in the panel, and thereafter getting an appointment, that itself, nobody can say that there is an element of fraud. First part. Second part is there was a probability that I was a part of the fraud. Now that is removed from the Pankaj and that mismatch that has been done. So once that exercise is done from the all records and it is found I am not attached with the fraud at all, should I, this is my point. Can I be said to be like equal to a person who is a fraudster? Kindly see, man, the devastating.
See, the fraudsters are out. What are you driving at?
Yes, I am driving at this, that one of the submissions of Mr. Bhattacharya was in paragraph 31, Supreme Court has observed after expiry appointment is illegal. And then Mr. Bhattacharya was trying to connect that illegality and tried an interpretation that since it is an illegal, therefore, I should also be treated as tainted. Now, my response to that, yes, it is illegal. Yes, it was found to be illegal. But the word tainted has been used not for the institutional illegality. Tainted has been used for the persons who have been identified by the CBI and for whose names are already there, not the persons who have been appointed after expiry but honest. So paragraph 31 is for the purpose of declaring the selection process to be set aside. It's like there are two different elements.
One no, but then is it only for the purpose of the prior teaching experience that you were saying?
No, prior teaching I will come later.
Then what?
My only purpose is this, that today there are thousands and thousands of persons. May I just give the fact? There were total 8 counselings because that part of the CBI report is also in my oppositions. They have given the dates and everything. And they found, even the CBI also found up to 7, there was nothing wrong. Only 8, they found it was done absolutely illegally. So all of us, we were called in the counseling and thereafter appointed range over from 1st to 7th counseling. If the interpretation of the writ petitioner is accepted, that paragraph 31 means illegality and illegality means we are also tainted, then we are completely gone. Gone in a sense, our participation, we cannot also participate, because one of the responsibilities that has been entrusted upon by the Honorable Supreme Court, that not even a single tainted person can slip through.
Hmm.
Now, assume that Lordship holds an interpretation that Lordship feels that even if, no matter that those who are in the CBI list, they are of course tainted, but those who are also appointed after the expiry of the panel, they are also tainted. Then what are the effect we get? The first effect we get is, once we are also declared as a tainted, that means for us everything shut. Not only shut, then as if we have practiced fraud, because even we are also up to December, we are going to school, we are also rendering services, we have participated in the selection process. So now everything comes to an end. Now may I my inspiration was not independent, it is from the Supreme Court judgment itself. May I just place 46 once more? Kindly see, my lord, the 45 is completely a separate paragraph from 46. There was a purpose of the Honorable Supreme Court to make 45 as separate from the 46. The purpose was this: 45 was, you return the money because you are a fraud. That is 45. 46 is, there were lot of violations. Therefore, though you are continuing the service for last 5-7 years, but still you lose the job. So selection process is set aside. These two things are different. Maybe there is a common connections up to the cancellations, but thereafter it's different. May I just read for my satisfaction? Both 45, the last question relates to the relief and whether it requires any modifications. We find no valid ground or reason to interfere with the directions of the High Court that the services of tainted candidates where appointment must be terminated, and they should be required to refund any salaries, payments received. Since this is the reason, since their appointments were the result of fraud, this word, the result of the fraud, is based on paragraph 22, the internal paragraphs, then the column in 25 and 26. This amounts to cheating. Therefore, we see no justification to alter. This is not plural, this THIS. So, this direction, that's the directions of the Honorable Single Judge for returning the money by the persons who have done fraud, who have done cheating, the Honorable Supreme Court did not interfere. After that, the Honorable Supreme Court, 46, for candidates not specifically found to be tainted. That answers, that's our savior. This first part of 46 is a completely portion carved out for the honest persons like us. For candidates not specifically found to be tainted, what happens in their case? Returning money. In our case, the entire selection process has been rightly declared null and void due to egregious violations and illegalities, which violated Article 1416 of the Constitution. As such, the appointments of these candidates are cancelled. Kindly see thereafter the word. However, this is the, my lord, this is the paradox. However, candidates who are already employed, that's us, need not be asked to refund or restitute any payments made to them. So therefore, I would put it this way. However, we are not treating you honest persons like 45. However, their services will be terminated. So this is like, there is a larger circle. Everyone gets affected. Honesty, dishonesty doesn't matter. That's the termination. That's the selection process goes. And there is a smaller circle. Because you are a fraud, because you have given money, because you have done corruptions, and that has been identified from the old records by the CBI, you return the money. So 45 equals to tainted Who has to return the money? 46 equals to not specifically found to be tainted. Now, why I am using this? Kindly see the word 46. The first was for candidates not specifically found to be tainted. So that assumes there are some other persons in the same judgment the Honorable Supreme Court found to be tainted. Who are they? Are they of everyone under paragraph 31 because of the expiry of the panel? Then 46 doesn't have any meaning afterwards, because then it has a word, as I say, however. However, candidates who are already employed need not be asked to refund or restitute. That's a complete contrast from 45. Any payments made to them, however, their services will be terminated. Furthermore, no candidate can be appointed once. This is of course. Then kindly see next para. Then 47. Now 47, this is another hint that in the 40s. So if I put it in this way, 45 equals to tainted, corrupt persons, return the money. 46 equals to you lose your job, but because you don't come under 45, you don't return the money. But still, because you are a part of this institutional failure, this entire selection process goes. 46. Now in 47, there are some persons who also had a earlier job. Now they thought maybe they want to come closer, or maybe they want to upgrade. So they also sat in the examination in 2016. The Honorable Supreme Court in 47, may I just place it, that 47, Lordship might find, if I can use this word, there is the same frequency in 46 and 47. And there is a different frequency in 45. The frequency in the 45 is the frequency of fraud and corruption and cheating. And the frequency in 46 and the 47, that is all about gross violation, violation of Article 14, 16, institutional failure, and thereby cancellation. And 47, some of the appointed candidates who do not fall within the category of tainted candidates. Well, so therefore 47 also begins with similar way 46 started. Can you see, my lord? 46 starts with 4 candidates not specifically found to be tainted. 47 also same. Some of the appointed candidates who do not fall within the category of tainted candidates may have previously worked in different departments of the state government or with autonomous bodies, etc. That's an old job. In such cases, although their appointments are cancelled, that means they are like us, they also lose the job. These candidates will have the right to apply to their previous departments or autonomous bodies to continue in service with those entities. These applications must be processed by the respective government departments within 3 months, and the candidates will be allowed to resume their position. Further, the period between the termination of the previous appointment and the rejoining will not be considered a break of service. Their seniority and other entitlements will be preserved, and they will be eligible for increment. However, for the period they were employed under the disputed appointment, no wages will be paid, state governments or autonomous bodies. Further, if required and necessary, supernumerary post. Kindly see, my lord, same frequency between we and 47. Factual difference.
All of you who you are representing were appointed after expiry of the panel.
Most of us probably, because it's a mix. But as my understanding, because in the conference, as they say that the majority of the absolutely clear tainted corrupt persons, they were in the so-called within expiry, first and second panel, most of them. Kindly see, my lord, I would say how the Honorable Supreme Court have kept the similar frequency for both of us, 46 and 47. For 46, because we are untainted, we are permitted to, though we lose the job, to participate afresh. Because
does untainted and specifically not tainted mean the same?
it does in this context. because one of the things.
Very well. I got the answer.
May I also say why do I say so? Why lordships give dictations or writes the judgment? This is not like a scientist in the laboratory in a mathematical precisions doing something. So therefore, every time when lordship's judgments have to be understood, we have to understand the context and in what circumstances. So if I go the etymologically or deep, anybody can make a thousands of one different. But in this context,
Synonymously used.
yes.
So does it mean that if there is total number of say 10,000 candidates,
Yes.
and out of which say 500 or 1,000 have been treated as tainted,
Yes.
then the other remains untainted or not specifically tainted?
Absolutely.
Right?
Absolutely.
If that be so, then the commission is coming out with a list of tainted candidates.
Yes.
Others become not specifically tainted or untainted.
Would your lordship say it once more because I missed.
There are, suppose,
Yes.
in small figures,
Yes.
1,000 candidates.
Yes.
Out of them, say 100
Yes.
have been found to be tainted.
Correct.
That means the other 900 remains untainted,
Correct.
non-tainted, not specifically tainted.
Absolutely.
This is the
Yes. I think it is to my understanding, it is absolutely clear.
right.
Because the lordship will see that, as I was using the how the judgment of the Honorable Supreme Court was clearly resonating with the CBI's reports. It's not resonating differently. It's in the same frequency that I have my lord stressed on the words all data of Pankaj versus all data of SSC. Then data of Pankaj was not tainted, and data of SSC, my lord, only used to match whom actually they gave the benefit because of the corruptions. And thereafter, they found these are the corrupt persons. Kindly see, my lord, the deeper aspect of the justice delivery system. I was thinking this. On one hand, it is your lordship should be ensuring that any process is free from corruptions. Therefore, there has to be absolute thrust. No corruption slips through. No tainted slips through. Simultaneously, just for a hypothetical reason, assume of a candidate who is honest. Suddenly, for no reason, if he is stamped as a dishonest, in my most respectful submission, I would say that would be, if the justice delivery system is not, it does not protect that candidate for whatever reason, to my understanding, that would also be equal failure. Because there are two sides of it. It's just to find out the good should be preserved, bad should go. So while doing the act of bad must go, there is a simultaneous, I would say, it's a simultaneous also, that every time your lordships do so, also ensure that a good person suddenly for no reason doesn't become bad. So once we have been found to be untainted, which have been synonymously said to be not specifically tainted, today, based on an interpretation of 31, which is, I would say, 31, if lifted from the whole context, it is possible to give an interpretation of that. But if 31 is put in the place and read with 25, 22, 45 different treatment in 46 and 47, in my humble understanding, my lord, the only one and only interpretation is that if you are a corrupt, you are tainted. If you are tainted, not only you lose the job, you also return the money. If you are not a corrupt, we feel for you, but you also lose the job. If you are already serving, you get back, and not only get back, you get the continuity of the service. But since you didn't have a job earlier, for us, you participate afresh. This is in 51. That's the reason, my lord, I say that. No, then 49, may I say 49. Before 49, just 51. So for returning money in 45, the Honorable Supreme Court found that the Honorable Single Judge was right, and therefore we are not interfering. Perfect. But then 51, the Honorable Supreme Court had to modify, because in modification has already been done in 46, 47. 46, 47, 46 for us and 47 for who also had a previous job. That's all about 51. Accordingly, we uphold the impugned judgment, cancelling a block entire selection process. This is the word. But have made certain modification. Rachime Kali Mark, according to my understanding, this is modifications is in 46, 47. In the direction issued by the High Court. Because the High Court, though when I read the judgment of the division bench, in fact, there is a possibility, my understanding was that possibly also High Court did not say so. High Court also, but maybe the language, there is a possibility in the High Court judgment to be read as if the High Court wanted everyone is tainted. But if the other paragraphs are read in context, that will not be the interpretations. But once the Supreme Court has said, well, there is no requirement, because 51, my lord, the upholding is, Lordship may kindly see the entire selection process, that cancellation, that's the upholding. But have made certain modifications means the 46, 47 and 49 that we can also participate again. So on this judgment, I will only say one sentence and I will conclude on this topic. Therefore, my lord, the added respondents who have been appointed because of their merit in a better situation, my lord, they are untainted. It can be used as they are not specifically tainted. And therefore, paragraph 31 of the Honorable Supreme Court judgment does not make them tainted. Paragraph 31 is only for cancellation. Now I will come to, well, I began first with this because if we fail on this point, then we fail everything. On this point, if we fail in a sense, if in case there is an interpretation that in paragraph 31, the Honorable Supreme Court has said illegality, and therefore we are also tainted, and then the only, in fact, my lord, the situation is this today, even the beneficiary of 47, because I am the, in not in this matter, in another matter, there are about more than 200 persons who are working in madrasa. Now all prepared, everything is done, ready. Madrasa is also going to give them appointment because they're an old job. But now because of this, that whether persons who were appointed after expiry of the panel, are they tainted? If they are tainted, then they will not get any benefit. They should be denuded of all the benefits. They cannot participate. They have to return the money, all. So that is, in fact, everything is, as I said in the other matter, that even some schools, when they want to go, someone is saying, wait, let us understand whether the Honorable Court ultimately holds that you are also tainted or not. This is the situation. Well, may I now go to the rule point? Well, before beginning on the rule, I shall be slightly using, usually, my lord, as a counsel,
Yes.
now, my lord, I shall be requesting your lordships for some time to use the lens of a mathematics, leaving aside the law for a few minutes. And then lordship will have a very beautiful angle of this matter.
Yes.
Well, this is now I am on the rule, 10 marks. Well, I have studied the rule thoroughly, and I spend lots of time in the rule, and I had a couple of questions. Before Lordship looks at it, may I just, then I have tried to use, leaving aside the law. Law will come, of course, come, but I found mathematics is one of the best things by which we can look everything in an equal manner. So why not I exclusively use mathematics to give to explain, does it really tilt? Firstly, does it tilt? Secondly, if there is a tilt for 10 marks, is it reasonable or unreasonable? That's a law point. Firstly, does it tilt? Now, there are 100 marks. Out of 100, 60 is for written. Academics, that is qualification parts, that's 10. The bone of contention is 10 prior teaching experience. Now, when I say 10, I would be requesting your lordships to look at not as a 10. Look at, Kali, take the rule. Can it straight away come to the schedule 2? That 25, that's it. Lordship will first kindly see. First, I would be saying on an area where there is no problem by anybody. That is educational qualification under 2A. Nobody has questioned that this is wrong. How much is the marks? 10 marks. Now, this 10 marks is to be given under 3 buckets. The buckets are 60% to 100%, he gets the 10 completely. And then second bucket is 60 to 50, he gets 8. And then 50% below. So if I put it this way, below 50, he gets 6 marks, 50 to 60, 8 marks, 60 to 100, 10 marks. So therefore, there is 10 marks spread over under 3 buckets. Nobody has any grievance on that. So everyone is recognizing that it is possible that if someone is better in the educational qualifications, his bucket may be different one.
This was not there in the 2016 recruitment rules. This bifurcation was not there.
These 3 buckets.
Right. Did you make any comparative chart between the earlier rules and the 20?
I did with the 2007, but I would do that.
Yes, please.
I would do that. I would do that. I was trying to, my lord, because my mind was to find out some mathematically. First, I was trying to understand where do I stand from a neutral point of view. Thereafter, I will make my submission. I found for educational qualifications, there is a bucket, 3 buckets. So this marking. For prior teaching experience, my lord, that is in more granular form. There are 5 buckets. Because it says
2 marks per year.
Yes. So that means if someone has an experience of 1 year, he gets 2 marks extra. So when Lordship is looking into this issue, it's not necessarily an issue of 10. There could be some persons who has only maybe 1 year or 2 years. It could be 2, it could be 4.
There can be somebody who has got below 56 marks.
Yes.
And has 5 years and 6 years experience.
Yes. Yes.
Gets the 6 marks and the 10 marks 16.
Correct.
And somebody who's got above 60 merit-wise stays at only 10.
Absolutely. Right. I was trying to make a contrast. Now, my lord, can you take my third page? The last, where the Roman 6:1.
Yes.
What it takes for a freshers to win. I was trying to understand the freshers versus we.
Yes.
I found some interesting mathematical thing. 1 year experience, it requires the freshers to get only 2 marks more in the written. So written is 6 times more powerful because it's 60 and this is 10. 6 times more powerful. In the entire selection process, if someone is a better candidate, in a sense, if someone has written 2 marks better than my lord, someone who has an experience of only 1 year, there would be a tie. For 2 year experience, my lord, freshers has to be better by 4 marks. And I have come to, for 3 years, 6 marks, for 4 years, 8 marks, and for 5 years experience, a freshers needs to answer better 10 marks. So if lordship kindly take Roman 7. What I am trying to draw is this. This means that written exam is 6 times more powerful than experience. The above example may demonstrate mathematically that number one, a freshers who performs well in the written examinations can easily beat even a candidate with maximum 5 years experience, but he has to be a better student. Number two, the experience advantage can be neutralized by scoring an equivalent number of additional marks in the written examinations. So it's not a dead end. It's a Darwin's survival for the fittest.
Here, everyday matters are moved for 1 mark.
Yes, correct.
In fractions.
Correct.
And prior teaching experience, the maximum is 10 and the minimum is 2.
Yes.
So it has a deciding factor.
It does. But I'm saying, lordship, kindly lift the veil of it. Kindly go into the factor. The factor is this. If you don't have experience, what do you have? For an example, my lord, many of us, if we compete today with a
Pressure.
10th semester law student,
Right.
I am
Fail.
100% sure that we will fail.
Yes, I know it. I am aware of it.
So therefore, life requires skill.
Right.
Now, skill can be said in thousands and one words. Experience is one of the expressions being used where it's a life skill, which is the truth. Now, if somebody has this skill of life to teach students, to match that somebody, one needs to be a better student. I could have understood that his door is shut. No, he has 6 times more powerful avenues where he can compete. So therefore, the mechanism becomes this. If you have to compete with a person who has a skill, that's an experience, you have to be better in your studies. In 60s, in that, now kindly take the first page. I've tried to all the situations. Freshers versus 5 years. First example is the example of tie. Freshers
don't go to this such minute details possible.
No, I'm not minute, but I'm only trying to, my lord, because sometimes what happens, my lord, unless lordship is looking, if lordship looks at the this issue, that there are so many persons who are having identical marks. This is on surface. If lordship go deeper aspect of it, lordship will find the performance of those so many persons. So my endeavor before your lordship is this, that the performance, there are two sides of it. One is the skill side, another is you have to be a better student. I could have understood it is impossible that the written examination is not of 60, it is of 30. Then it would be a Herculean task, because my instruction is our total number of vacancies are around 35,000 and around 20,000 are actually they have got from the freshers, because freshers are always better in academic, bound to be. Well, their processors are always better than us. It is the normal thing. That's the evolution. But in that evolution, does it recognize the skill of experience or it does not? Or does that recognition of experience, does it make that competition so difficult for them that it can be said to be violative of Article 14 or not? To answer that, in a deeper level, I say that if a freshers gets 48, when a 5 years candidate, I'm not saying even 1 year to 5 years candidate, he gets a 38, educational qualification, I take it, everyone is getting 10. Both of them will be having a tie. Both of them would be a 58. And for a freshers to win, for an example, example 2, I have given that In written examination, if a freshers gets 50, in that case, he would be winning. And that the example with the 5 years. Similarly, for 4 years, for to win freshers, he needs to have written examination 47, basically only by 2 marks. So sum and substance of this, my lord, that's why I said I would be using a little lens of a mathematics, that if lordship look at a glance, of course it makes a difference.
And you have not added those marks which have been given to all on attempt. You have not added those marks, not even attempted, but given marks. You have not added those marks also. The answer scripts have been published, and there are marks given. Two answers in one question is treated as right. Without even attempting, you are getting marks. Anybody who attempts also get marks. What is this?
May I say this? May I say
Yes,
this?
please.
Well, life will give thousands and one problems. Now, lordship is already having won this because the Honorable Supreme Court has entrusted. It is impossible to solve every problem. Maybe that's also fundamentally not the purpose of life. I don't. That's a little nothing to do with law, but something to do with beyond it. But not making any attempt to solve a problem and assuming that the world would be without any problem, possibly that world may not be, because often I see this, that one of the beauties of the human beings that we are imperfect. Because very soon we would be realizing when there would be lots of robots, there would be complete perfections. Maybe one would be exactly like others. So all I say, no matter how much efforts are there would be some mistakes, there would be some problems, there would be some kind of imperfection. Maybe life is all about that. But when lordship is looking into the rule to test it, whether it is to be declared as a violative of Article 14, then lordship also draws the very philosophies from the life itself, which has one component of you have to be a good student versus do you have a better skill or not. So if the state, if they have chosen, in my understanding, rightly chosen, but there can be a different possibility also, that I want to give 2 marks, 4 marks, 5. I'm not using the 10 marks deliberately because it's not directly 10. So I want to recognize and give some weightage to a person who has a skill. Is it fundamentally flawed? My lord, my respectful submission before your lordship would be, possibly this is fundamentally, it is possible that when a corrupt institution does so many corruptions, then there is an every apprehension that even a good thing they might make it bad. I understand that. I do. I can't talk out of. It's true, but looking from the point of view of the constitutionality and legality, recognizing the experience, which is a skill itself, that itself, now that could have been, I would say that could have been violative of Article 14 had there been no field for 60 marks in the competitions. I say that what does it make? What is the impact of it? The impact of it, the competition becomes harder for the freshers, meaning thereby, if you are a fresher, you have to be a better candidate. You have to be academically better than a person who was working. So therefore, choice which is being made by the state, that we do recognize the skill, therefore we give an weightage. And because we do this narrowing, we are making it harder, we are getting better candidates. But ultimately, it is 35,000. Even if I don't know how many lakhs, I assume there may be lakhs and lakhs persons. So therefore, only the persons who are better, and within the better, for the timing, for the timing, assume that 10 marks is not there. Then what happens? Many of the candidates who had the experience, they will not be able to. Why? Because in that case, this I would say this intangible part of it, the educational qualifications is a very tangible one. He got this percentage of marks, very tangible. But the experience, now, if someone asks that you have practiced law for 7 years, 10 years, versus a person who is excellent, he might be first or second in his class, just passed law. What's the difference between these two persons? Well, there are, we recognize, sometimes we may not be able to articulate it, but we really do understand that while dealing with the problems of life, the persons with experience might have some age, which is fundamentally very intangible. And recognition of that age, which is intangible, from a source of persons who have been screened and found to be not tainted, and coupled with others, because of course it's not us, anybody, there may be others also. Mr. Mitro has also said, Lordship might definitely say that they have made it is hard competition for the freshers. Yes, they have to 2 marks extra, they have to have 4 marks extra, but still there is a huge avenues for that. That's the reason 20,000 of them, they are there. So if you, let's say, take it that way, 35,000 of freshers are 20,000, so it's there are huge number, more could have been there. So lordship might see that it is itself is not flawed, could have been flawed had there not been a 6 times more powerful avenue of written examinations. So therefore, fundamentally the rule, if I can say this way, fundamentally the rule chooses the best person. They are getting the best students from freshers, and they are also getting, I would say, average or lesser best, but with a better skill, which is also the other aspect of Article 14, that we are recognizing that there is some amount of not equality. Someone having experience of 1 year, 2 years, at least he knows how to handle with students. He knows a couple of things. So therefore, they being not equal, I would say that Article 14 has been translated into reality, and that has been sprayed over and sprinkled in this variety of the schedule. Well, I will make a comparison on 16 and 25 also. Now, my lord, may I go to the rule itself? Well, there are, since I was making submission on the rule itself, I thought if I make the submission on the rule, and when I go to the judgment, I will go to the judgment touching upon all these topics. Well, my respectful submission before your lordships on the rule, dealing with the point at what stage, is that the rule itself is absolutely clear at what stage, and that stage is before interview. And why do I say it is before interview? That's the my answer. First, I say that in every rule, there are definitions, rule or in the act, and there are substantive provisions which operate, and there are schedules which are for more minute details how that operation will take place. Here also there is a definitions which is there, I would say they are banking on the writ petitioners. But there are substantive part. First, may I The definition, Lordship would first kindly see that starts 2-1. In these rules, unless the context otherwise requires. There are judgments, I shall be giving it later on. So therefore, the very definition clause begins with the understanding of flexibility of the definition itself to say that do not read the definitions in contradictions unless that context requires so. I give you a definition, but that is not an watertight. It is flexibility and it has to be in sync with the context. With that 2-1 broad head, now comes 2K and 2L. First 2K, interview list. Interview list in respect of the SLST state level selection test means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit for oral interview. So kindly mark for oral interview and lecture demonstration, not post, category wise on the basis of preliminary merit score, that is score from a written test. In this case, state is not relevant, and academic score in the ratio of 1.6:1. That is for 160, 100 of final vacancies. So this is the definition of the interview list. Well, it doesn't really say where to operate, where to be done. Thereafter, this is the merit list, which is the writ petitioners they have banked on. Before, my lords, referring to merit list, the substantive part, if your lordships kindly have a look at, lordship will see there is a separate substantive rule for merit list and there is a separate substantive rule for interview list. For interview list, the substantive part is there. Rule 11, sub-rule 8. Before reading it, lordship may kindly contrast it with sub-rule 16. This deals with the merit list. After interview, Roman 16.
Roman 16, yes.
Yes, I was on rule 11,
yes, yes.
Roman 16. Because I want to answer first what they have formed. After interview, the interview board shall forward a detailed report to the Central Commission, which shall, from the interview list and on the basis of the report of the interview board, prepare and publish a merit list category wise on the basis of the merit as per Schedule 2. The merit list shall contain the names of all. So therefore, under the substantive portion of the rule, there is a specific portion where merit list has been used, that is Roman 16. Whereas, kindly see, my lord, Roman 8. The Central Commission shall prepare and publish in its website a preliminary list with details of the candidates to be called for interview. So therefore, it is for interview clear, subject to verification of credentials, not relevant, and eligibility category wise. On the basis of preliminary merit score, I could have understood it is ended here, but no. As defined in Rule 2.1K, kindly, my lord, read, not read, kindly see the absence of K. The absence of K is there. Sorry, I just, absence of L is there. Sorry. I was, the expression of your lordship, I often, my lord, I do say, words are most of the times not the thing itself, it carries what is something, I don't know whether should I use the word insight or. So when even in our conversations, we know every little and our whole system understands. I understood that I was making a mistake from lordships. So L is not there. So absence of L, what is to be done, what list to be prepared for interview, the rule itself is clear.
Yes.
I would say this way. Absence of L justifies presence of L in Roman 16. And that makes it clear that schedule 2, now Lordship kindly come to schedule 2 sequence. So that's the entire context and objects ought to be achieved. That the substantive portion of the rule refers the interview preliminary list only. It doesn't refer about the merit. And then the sequence part Lordship gets it in schedule 2. Well, at schedule 2, to my understanding, the sequence is so clear that it says, I would say, kindly look at the first, the number. Number 1 is the written examination. So that's the area where one has to be the best. 6 times powerful, as I said. And number 2, that's the number. Academics has 2 components. It's a small a and small b. The small a has 3 buckets, which can also be said to be arbitrary. Somebody can say that I'm getting 80, so therefore 60 plus and even 100 are in the same bucket. It's possible. So that's why I made a comparison that prior teaching, that is more granular. This is more compartments are there. But Lordship may also consider that if we call it arbitrary, I don't want to call it arbitrary. If we philosophically, not legal arbitrary, if we call it arbitrary, but there is always a point which can be said to be arbitrary. If Lordship draws from life itself, which is the part and parcel of the law that I do believe, then somewhere there has to be a full stop. Somewhere there has to be some kind of collateral damage which may not have any legal right, which has to be accepted. There may not be a law which would address for every individual variety circumstances. Somewhere has to be, but effort has to be made. Is it so wrong? Or no, some efforts have been made. For an example, for educational qualification, I would look at, it is fair enough. Yes, could have been even the 5 buckets. I don't mind it. But I would say that it doesn't make you of that kind of candidate that who would say that it makes that competition level of 60 marks becomes harder. Yes, it puts you with some others in the same bucket because it is only 3 buckets, not a 5 or not a 6. But still, if you feel that because your educational qualification was better, you are a better person, compete better, become a better student actually in the examination itself. That scope is there. Therefore, existence of that scope, which is same for everyone, neutralizes quote and unquote arbitrary. Can I resume?
Yes, it's nearly 30.
Yeah, that's what I'm saying. So, not, it's 30.
One.
No, but it's a 30.
Yeah, it's 30.
What?